Good evening and welcome to this special edition of Chicago Tonight on this Friday, October 5th. In one of the most highly anticipated criminal trials in decades, a verdict in the murder case against Chicago police officer Jason Van Dyke.
We, the jury, find the defendant, Jason Van Dyke, guilty of second-degree murder.
Police officer Jason Van Dyke is in jail tonight after being convicted of second-degree murder and 16 counts of aggravated battery.
He was a trained professional of 20 years. To me, he should have thought more carefully.
Jurors also say the dash cam video played a key role in their decision to convict.
Everything we went through was perfect.
Second-degree murder, y'all.
Community response to the verdict and what organizers say they hope for next.
It really is kind of a sad day for law enforcement, I think.
More on law enforcement reaction to the verdict with Chicago Police Union President Kevin Graham.
It's still rather surreal to me right now.
And we hear from one of Laquan McDonald's family members about his thoughts on the verdict and the future. All that next on this special one-hour edition of Chicago Tonight. The city is reacting tonight to the unprecedented conviction of Chicago police officer Jason Van Dyke. The officer was convicted of second-degree murder and 16 counts of aggravated battery for killing 17-year-old Laquan McDonald back in 2014. Thanks for joining us. I'm Phil Ponce. Jurors speaking after the verdict said the deliberations went well, and they questioned why Van Dyke chose to escalate the situation.
The deliberations were, I think, they couldn't have been better because we listened to each other. We respected what each other said. When somebody was questioning something, we let them ask their questions, and we worked with it until we all came to a consensus.
It seems the way you're talking that the question was to convict on first or second. Was an acquittal ever on the table? Did anyone come in the room saying, I don't think he's guilty at all?
No.
Really?
And he was a trained professional of 20 years. To me, he should have thought more carefully about the situation and the time in which that he got out of the car before he started shooting.
He needed to contain the situation, not escalate it.
Here now with more Chicago Tonight's Matt Masterson, who has been in the courtroom throughout the trial and was there for the verdict today. And by the way, Matt, the jurors were not identified by name. They only identified themselves by their jury number. That's how we didn't put their names up. And also, some jurors chose to just allow themselves to be interviewed by audio. These were two jurors and one alternate who opted to speak on camera. But there seemed to be little doubt that the jury was going to convict Jason Van Dyke of something. Why did they say they went with second-degree murder instead of first-degree murder?
Well, the jurors who did speak out, they made it clear that they were leaning towards a conviction pretty much from the onset of their deliberations. We heard that they took a straw poll right when they started, and immediately 7 people were in favor of conviction. Only two were favoring not guilty. So it seemed like right from the start that they had their mindset on a conviction. The reason they went for second-degree murder over first-degree murder, it came down to mitigating factors. You more or less have to prove the same thing as a prosecutor to convict on first or second degree, but what it comes down to is that the jurors believed Van Dyke they believed that Van Dyke believed that he was in danger when he did fire at Laquan McDonald, but they felt that that belief was not justified. It wasn't rational or reasonable when he did pull the trigger, and that's why they convicted on second-degree murder. Speaking after the verdict, jurors said how they felt putting Van Dyke on the witness stand was a misstep. They felt his story felt rehearsed. They didn't find him as a credible witness in certain points. And they never felt that McDonald posed a real threat to Van Dyke. They felt he should have stopped at some point during the shooting. He should have stopped before the shooting.
So he's convicted on second-degree murder, 16 counts of aggravated battery, aggravated assault rather. What does that mean in terms of a possible prison sentence?
It is aggravated battery. We know it's going to be at least a minimum of 6 years. Each of the 16 aggravated battery with a firearm counts that he was convicted on. It's a Class X felony. It carries a 6 to 30-year prison sentence, so he's going to be going away for at least 6 years. Second-degree murder also carries a 4 to 20-year prison sentence, but it doesn't require prison. He could receive probation on that sentence. So he can be sentenced on multiple counts, but it's not yet clear if prosecutors are planning to seek these to be served consecutively, which could mean 16 counts, 6 years apiece, or if they want them served concurrently, in which they'd run together.
Well, as you know, Matt, this case has been such a flashpoint between the community and law enforcement. And today, Special Prosecutor Joseph McMahon said that he hoped the trial and the outcome would help heal the relationship between law enforcement and the community.
We all know that this verdict does not bring back Laquan McDonald. We have kept our focus on the actions of Jason Van Dyke the night of October 20th, 2014. The end of this trial marks an opportunity for this city to come together. This investigation, this criminal prosecution of Jason Van Dyke, I believe reflects our shared values. Laquan McDonald was not a throwaway young man. He had his challenges, as many teenagers do, and he should have been arrested that night, but that's where this story should have ended. Over the past 2 years, we committed ourselves to seeing that justice was served for Laquan McDonald and the people of Illinois. And although I take no personal pleasure in this outcome, I'm satisfied with the result, and I hope that it begins a new chapter in the relationship between law enforcement and the community.
Matt, family members and activists were both inside the courtroom, outside the courtroom. What was their reaction when the verdict was read?
Well, the courtroom leading up to the verdict being read was incredibly tense. That courtroom hasn't been filled every single day during this trial, but it was standing room only today. When the verdict was announced, courtroom was more or less silent, save for the judge's clerk who was reading off additional verdict sheets on the aggravated battery counts. So Gahn had warned people several times not to make any noise, that if they did make any sort of outburst when the verdict was read, that they would be arrested and taken out. So Van Dyke didn't have a huge reaction. His family and McDonald's family, who were in the courtroom, didn't have a huge reaction at the time, but we did see that some of the attorneys were shaking hands, some of the prosecutors were shaking hands, and Van Dyke's attorney, Dan Herbert, was patting him on the shoulder as he was led out to jail.
Was there any expression of disappointment when the verdict was second-degree murder as opposed to first-degree murder?
Not from the prosecutors or the activists who were at the courthouse. Joe McMahon, the prosecutor, said the verdict holds Van Dyke accountable for his actions, and it proves justice and validation. It provides that for residents of Chicago. So he said that he was not at all disappointed in the second-degree murder charge, nor were the activists who were there. As for McDonald's family, the Reverend Marvin Hunter spoke after the verdict, and he called it a victory. He called it a victory for families not only in Chicago, but also across the country. So it may not have been the top first-degree murder charge that they had charged him with, but it seemed like the people who were in favor of a conviction were happy with the result.
As you know, before the trial, the defense very much thought that that Van Dyke could not get a fair trial in Cook County, and they wanted the trial moved elsewhere. And lead defense attorney Dan Herbert questioned the refusal to move the trial venue outside of Chicago and said his client was sacrificed to protect others.
I think anyone that is familiar with this city and familiar with the criminal court system in Cook County knows beyond any doubt that he was an absolute sacrificial lamb. He was sacrificed by his leaders, by political leaders, by our supposed community leaders, and it was all for one reason, to save themselves and sacrifice Jason Van Dyke. So we said that from day one, and nothing has changed since.
So what is the possibility of an appeal?
Herbert said that he's going to explore his options. I don't believe he specifically said that they would be appealing, but he said he wanted to revisit the change of venue motion issue, which was rejected. He wanted to move the case outside of Cook County, obviously believing that he couldn't get a fair trial here. So him saying that he wants to revisit that would imply that there will be an appeal. After the verdict was read, Kevin Graham, the Fraternal Order of Police head in Chicago, he said he had much more marked words. He said, "Mark my words, there will be an appeal."
And we'll be speaking with Kevin Graham a little later in the show. Matt, thank you very much. Community activists and organizers began gathering outside City Hall before the verdict was announced, shortly before 2 this afternoon. Their demonstration, or as some are calling it, celebration, continued into the evening. Our Amanda Vinicky was there and joins us live. Amanda, what was the response like?
Phil, I was outside of City Hall and watched a huddle of people. I'd say it began maybe 150, 200 individuals who were actually very quiet. Some held up their cell phones, listening to a live stream of the court proceedings. Some hollered, but really they were quite quiet. I believe there were also some tears. This was very emotional for some of the activists who had been calling for, demanding justice for Laquan McDonald in what they said could only be served by a guilty verdict for murder. One of those activists, those organizers that was there is Tanya Watkins, who is here with me now. And Tanya, what was it like for you? What was your reaction to hearing that verdict guilty of second-degree murder?
It was very emotional. I think that as we waited for the verdict to be announced, people were shaking. I think that everyone was on the verge of tears. And when we heard the word guilty, a lot of that emotion poured out, right? People understand that, we got closer to justice today, but the reality that Laquan McDonald is not here is, sobering. And somber. So it was more of, a gathering of grief than a celebration initially.
And why is this so significant for you? I spoke with organizers who called this a historic moment. They said never before has there been a police officer, let alone a white police officer, convicted of, while on duty, killing a black individual in the city. Why is this so meaningful?
I think that for most of us who live in and are from directly impacted communities, we understand that there are Laquans every day where we live, right? This is not the first time a young black man has been gunned down by police. Like, we've experienced this, we've lived this, and every time police officers get away with it. So this sets a precedence that, hopefully this verdict will reverberate through the police department, through City Hall, that you cannot hunt us down like dogs and devalue our lives.
And today, of course, there was a march. It began at City Hall, went around City Hall, through parts of downtown, and really you had activists taking over, and a groundswell is what it became. As I said, started with about 150, 200 and became many times more than that, eventually overtaking the northbound side of Michigan Avenue. This was a march that was meant to do what?
I think that people needed to feel their power today. Like, the reality is, these are our streets, right? Point blank and period. They belong to the citizens. And, the police should ideally serve us. But until we learn to live and walk in our power and claim what's ours, we can never expect the system to bend to our will. So this was a display of power, people being motivated to do more work. We have a ton of work to do around dismantling the criminal justice system. And I think that folks feel that, they hear that, and they are ready. And this energizes them to, bear down and continue this fight.
So those are the next steps. What specifically are you asking for? What is that fight you're hoping, what will it lead to?
Absolutely. So we want authentic community control of police, right? Police boards should be made up by citizens, not elected and selected by mayors. We want to make sure the city council is dismantling the FOP contract to ensure that, the contract protects labor and not murder. We want to make sure that militarized policing is removed from our communities, and then we're actually investing in communities and not in policing and criminalizing black bodies. That is what we want. We want policy, we want legislation, we want the aldermen and the mayor, whoever that will be, to stand behind the people, right? And not, you know, depend on racist policing to control communities.
And I also did hear from a lot of those who were marching calls for ousting the 34 members of the Chicago City Council that they say were part of a cover-up and having approved the settlement. This march, as I said, did go on for many hours, started just after the verdict at about 2 and carried on until just before 6 this evening. I witnessed no violence. It was peaceful, loud. The only shouting really that was going on besides chanting was from one individual who was upset that that she was stuck in traffic. And with that, Phil, take it back to you.
Thank you, Amanda. And now to Eddie Aruza with the legal view of today's historic verdict. Eddie.
Phil, it took the jury in the Van Dyke case only about 7 hours of deliberating to reach its verdict. And as we heard, the jurors who spoke to the media afterward said they found Van Dyke's testimony on the witness stand rehearsed and hard to accept, especially after what one juror said was many viewings of that now infamous dash cam video showing Laquan McDonald being shot 16 times.
We, the jury, find the defendant, Jason Van Dyke, guilty of second-degree murder. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with a firearm, first shot. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with a firearm, second shot.
Jason Van Dyke remained expressionless as one guilty verdict after another was read. And tonight, with his bail revoked, he's in jail, a convicted felon. And joining us with their legal analysis of the jury's decision are Richard Kling, a clinical professor of law at IIT Chicago Kent College of Law, and a defense attorney. He regularly gives lectures to lawyers and judges on the Illinois rules of evidence. Nancy Martyr is also a professor at IIT Chicago Kent College of Law, where she's the director of the Justice John Paul Stevens Jury Center. She has written and taught extensively about jury instructions, juror questions, and jury deliberations. And Sharon Mitchell, deputy director of the Illinois Justice Project. Previously, Mitchell served as a trial attorney in the Cook County Public Defender's Office from 2009 to 2016. Thank you all for being with us here tonight. Let me just ask a quick question. Were any of you surprised by any of the verdicts today?
No.
Any surprises at all? Any shocking revelations? Nothing. No. So, Richard Kling, let's explain, because Matt Masterson did a fine job of laying it out. But in terms of classifying the seriousness of the convictions today, second-degree murder, and then all of those assault charges, tell us the degree of seriousness there.
Strange as it sounds, the aggravated battery with a firearm is more serious than second-degree murder. Aggravated battery with a firearm is punishable by not less than 6 years in the penitentiary, nor more than 30. It is not probationable. Second-degree murder.
So a minimum of 6 for each count?
For each count at 85%. No parole, you'd have to serve 85%. Second-degree murder is 4 to 20 in the penitentiary. Those are the possibilities, but it's probationable. And so the bottom line is aggravated battery with a firearm is more serious than second-degree murder. Having done some research in the law in the last couple of days, what will probably happen is a couple of things. Number one, because the aggravated battery is more serious than the second-degree murder, the second-degree murder will probably merge into the aggravated battery, the less serious into the more serious. And secondly, there's an issue with respect to whether the sentences should be served consecutively, one after each other, or concurrently. And there's a body of law that says if you go bang, 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 right in a row, that's considered to be one act, one offense, which means it would not be consecutive.
But there is some doubt, as Professor Kling is saying, in the legal community about whether it should be considered one act or 16 separate acts. Why is that nebulous?
The law there isn't clear law on the issue, so there's multiple strands of law, and there are lots of practitioners that are kind of going back and forth on this question.
Nancy Martyr, as somebody who is very familiar and an expert on jury and jury instructions, what was the significance of, at the last minute, right before they went into deliberations, the judge giving them the option of second-degree murder?
I think it was so that they could reach an accommodation, a verdict that all could agree on.
So do you believe that first-degree murder was something that they would not agree on if that was their only option?
There's a possibility. So you want to come to something that's more within bounds.
So when they started the deliberations, the jurors who spoke out today said that 7 immediately said that they were ready to convict, 2 were said not guilty, and 3 others were undecided. Again, is the second-degree murder charge, that option, what brought them together, do you believe?
Well, there's a couple things. First of all, second-degree murder, you have to prove first-degree murder, and then the defense had to prove a mitigating circumstance, in this case, self-defense. Secondly, the law in Illinois is quite clear. If there is any evidence of second-degree murder, of self-defense, and the defense requested it, the judge had no choice. So presumably the defense requested that the jury be instructed on second-degree murder. And if that's the case, that's the case. I don't know whether it was an accommodation. If I were the defense lawyer, I would have been frightened of second-degree murder because I would see it that it's a potential compromise. On the other hand, first-degree murder would have required a mandatory minimum of 45 years in the penitentiary. That's a lot of time to gamble away.
Sharon Mitchell, one of the things that the jurors also said today was that they found Jason Van Dyke's testimony on the stand to be rehearsed. Now, obviously, anybody who takes the stand in their own defense, especially for a murder charge, is rehearsed by their defense attorneys. But why didn't the defense attorneys, I guess in this case, see that Jason Van Dyke might not come off as credible?
Well, it's difficult. At times, he remembered things very vividly. At other times, he did not remember things vividly. And I think juries want consistency. They want honesty. And I believe that in this case, the jury just didn't see a person telling a straight and complete truth. There were lots of questions about what version of story was told to whether it was his expert or whether it was to officers during the scene, on the scene, the day of the incident. So you have to be consistent.
Nancy Martyr, do you think that's where the defense lost its case when Jason Van Dyke took the stand?
I think you also have the very powerful visual, and it's really hard to...
The dash cam
video. And while videos can be interpreted in different ways, when you can look at something and see it for yourself, it can be very powerful. And as you look at it over and over again, it's really hard to compare.
And of course, they said that they looked at it, in their words, quote, many, many, many times. Do you think that there was ever any testimony that they could have presented that would have overcome that visual?
I'm hard-pressed to think of any.
So you think that that was already a given?
That's very powerful.
So the jurors who spoke out today sounded very confident about their decision. They said that they listened carefully. They didn't sound like they were forced into any kind of decision. But Jason Van Dyke's supporters tonight, and I think we'll be hearing from one of them in just a little bit, have already said that there is the Ferguson effect in play here, meaning the Missouri case in which Michael Brown was shot, a black man, by a white officer, and that set off riots and protests really around the country. Do you believe that this is at all factored into their decision today? Richard Kling?
I think I give them a lot of credit. From what taking them at face value from what they said, they deliberated. It wasn't a unanimous verdict at the beginning. It was like 12 angry men where they sorted it out. They looked at the pros, they looked at the cons. It was a hard decision to come to. I don't think it was a product of the Ferguson effect. I think it was a product of deliberations.
Sharon Mitchell, what do you think of that argument?
It's hard to get your head around. The fact of the matter is that there was a video. And not only was there a video, there was testimony asking jurors to believe something on the video that did not seem to be there. The combination of the two, the video and then the testimony that seemed to controvert what the video showed, made it difficult for the defense.
So there's a lot of Monday morning quarterbacking that might be taking place, and maybe we're already doing that here, Nancy Martyr. But as you look back, should Jason Van Dyke have gone with a bench trial? Do you think that would have made any difference as opposed to a jury trial?
I think the jury trial is the fairest protection that we offer to defendants. It's not a perfect system, but there is no perfect system. And I think the jury trial is what you do if you're worried about a fair trial.
And would it have made any difference if Jason Van Dyke had not testified, do you think?
according to my colleague here, he had no choice in a self-defense
In a
case.
self-defense case, there's only one person who can say, here's what I was thinking, and that's the person who was purportedly thinking it. That's Jason Van Dyke.
Of all the people in that courtroom today, you got a shout out from the judge, Judge Gahn. He said he praised you and noticed that you were in the courtroom there. Tell us what you felt and saw in that courtroom.
It was a tense courtroom. I was not involved as a trial lawyer.
You were there just as an observer.
But the second that they say there's a verdict, my heart is pounding in my chest because I've been through those verdicts on my own. In terms of Judge Gahn's shout out, I'll give him one back. It was a hard case. I know he had issues with the media originally, keeping them out of some of the proceedings. It was very difficult. It was very complicated. It was in the front page, as you know. It was a heater case. I think Judge Gahn did a magnificent job. I don't think the verdict would have been any different had they taken a bench trial. I think the law was the law and the facts are the facts.
So, Sharon Mitchell, what are the grounds, if any, that you can see for an appeal here?
Well, appellate attorneys will try, or appeal in the appeals process, they'll try to throw everything against the wall to see what sticks. But I think one of the focus will be the venue question, the idea that the case was heard in Cook County, and because of the sentiments around this case locally, that the defendant could not get a fair trial. There'll be other issues as well, but I suspect that will be one of the main arguments.
However, can I throw in a monkey wrench on that?
Throw whatever you want,
the
except
monkey
your
wrench
chair.
is, my
yes.
understanding is not all the challenges to the jurors were exercised. And the law is pretty clear. You have to exercise all the challenges to complain that you have a jury that wasn't fair. If all the challenges weren't exercised, I think that's going to be a losing proposition on appeal.
Nancy Martyr, describe the impact of a case like this on the jury.
On the jurors, or
on the jurors, excuse me. Yes.
Well, I think anytime you serve as a juror, it leaves a lasting impression. You can ask people 20 years later, and they'll remember the jury trial. I think people realize when they've served just how serious their job is, and they grow to take their job very seriously. And so it's something that stays with them. And I think immediately afterward, it's something that can cause them a great deal of anguish or stress because they've gone through this emotionally wrenching experience, but one that they're usually quite positive about afterward.
Well, they sounded very proud to have been part of the process or on that jury. Sharon Mitchell, there was a lot of talk as the trial began of the makeup of this jury because there was only one African American, and we heard from her this afternoon. Was that juror in a difficult position, do you think?
You know what? I'm not sure. I know a lot of commentary is centered around the fact that this would be about race, but I just didn't see it in the trial. There was one mention of Laquan McDonald being a black boy. There was a response in the opening by Dan Herbert saying that this wasn't about race, but the actual testimony, the actual crux of the case, did not center a lot about race, so I'm not sure that was a factor.
Richard Kling, this really is not over because next month there will be another trial of 3 other police officers who are charged with conspiring to exaggerate the threat posed by Laquan McDonald. So it's going to be another very serious case. Give us your preview of what might happen there, given what happened today.
If I were a defense lawyer in that case, and I'm not, I would be poring over this testimony and this jury because I would be seriously questioning whether or not I want to negotiate a plea. You know, realistically, it's clear now that the citizens of Cook County can convict a police officer if they believe the police officer did something wrong. And there are 3 police officers on trial. I don't know whether I would be looking to do damage control.
Richard Kling, Nancy Martyr, and Sharon Mitchell, thank you very much for your insights and being here tonight.
Thank
we
you.
appreciate it. Up next, the president of the Fraternal Order of Police on today's verdict.
Since the video of McDonald's shooting was released nearly 3 years ago, Chicago's police union has steadfastly defended Jason Van Dyke, and the union has criticized subsequent efforts at police reform as demoralizing and likely to make police hesitate to use necessary force when called for. Joining us now with his reaction to today's verdict is Kevin Graham. He's president of the Fraternal Order of Police Chicago Lodge number 7. And Kevin Graham, thank you for being with us on what must be a very difficult day for you. What is your reaction to today's verdict?
Well, we're disappointed with the verdict. We do believe that he should have had a change of venue, and that this should have been heard outside of Cook County, where people would have, I think, had a different perspective of things. I think what has been lost in this is that when an officer chooses to defend himself and ultimately have to use deadly force, that is a very serious decision that goes through his mind, but it is done in a blink of an eye. It is done with very little time to have any kind of a decision as to what there else may be. And of course, we're going to do our best, and we always do our best. The Chicago Police Department is one of the finest police departments in the world.
Kevin, if I can interrupt you for a second, one of the things one of the jurors said after the verdict was that what was key to her was when she heard Jason Van Dyke say that when he was in his car, he said something to the effect, "Oh my God, somebody's going to have to shoot him." So was it really
I think it was somebody might have to shoot him because of what the radio traffic was, and that people were saying what was going on the scene, and that he was concerned about the safety for the public and for other officers.
Some of the other jurors said after the trial, quote, he had other options, or he just could have waited. He was a trained professional of 20 years. He should have thought more carefully. Instead of containing the situation, he escalated it. Your thoughts on that?
Well, one of the things that the prosecution said was that there was going to be a taser there in 30 seconds. Jason didn't know that. No one had got on the radio and said there was a taser coming. And that's part of what the problem is when you have a trial, that maybe not all the evidence gets in.
What evidence did not get in, do you think?
Oh, I think there was a number of things. I think that we should have had more officers testifying about what the policies in the police department was, about the chain of custody, about the chain of events that took place, and that the shooting was originally justified. Well, who signed off on those? Those people should have been brought into court, and they should have been held accountable for why they felt it was justified, and for the process that was involved.
You mean subsequent to the shooting, the fact that several people vouched for Jason Van Dyke's actions? Is that what you're referring to?
I'm referring to the chain of command within the police department.
Speaking of other members of the police department, some people ask, why didn't the 10 or so other officers who were on the scene when Jason Van Dyke showed up, they didn't feel deadly force was necessary, evidently?
Well, apparently some people didn't feel it necessary to get out of their car. Laquan McDonald did attack the squad car where 2 officers were in, slashing the tire and trying to hit the windshield with his knife. I would say that those are very violent acts. And as that's being put out over the radio, I think that there is a heightened alert. Now, if somebody pulls up, and maybe pulling up not knowing everything that has transpired up till then, but has heard what has been going on the air. And so now there's a heightened alert. And now Jason pulls up, and there was certainly some confusion there. I know that...
And there was reticence on the part of other officers who were not in their cars, who were standing around, who did not feel compelled to shoot.
Mm-hmm. There were also officers that didn't want to go to the call and wanted to go to lunch instead. Now, I don't think that that's necessarily what we're looking for in officers when they're responding to calls.
But by supporting Van Dyke, is the FOP calling into question the restraint of the other officers who were there?
What we're concerned with is, and this is no different than when we have always said, is that we are concerned with the training and policies of the police department so that they are fair and make sure that the officers are safe as well as the citizens.
As you know, there was a statement issued from Chris Southwood, who is the president of the state FOP, and this is a quote: "This is a day I never thought I'd see in America, where 12 ordinary citizens were duped into saving the asses of self-serving politicians at the expense of a dedicated public servants. servant. This sham trial and shameful verdict is a message to every law enforcement officer in America that it's not the perpetrator in front of you that you need to worry about. It's the political operative stabbing you in the back. What cop would still want to be proactive fighting crime after this disgusting charade and our law-abiding citizens ready to pay the price? Your reaction to that statement, was that rhetoric appropriate?
Well, certainly he was in the courtroom. Those are his opinions of what has occurred. I certainly have made more restrained comments and addressed exactly what I have always said have been the problems, and that we did not have enough equipment, we did not have the personnel, and that those things should have been addressed. Certainly I believe those were political issues, whether you want to say it's a budgetary constraint or whether it was a desire not to address the things that we needed in the police department. However, those certainly were contributing factors that led up to this incident, and unfortunately now Jason going to jail.
As you know, some jurors said that acquittal was never a consideration by the jury. Does that underscore the clarity of what Jason Van Dyke did, that it was wrong?
Well, I think that was part of their job, was to consider that. And certainly that was put forward by the defense. Now, why they didn't consider that, you'd have to ask them that. I think it's important.
Well, presumably they found the evidence overwhelming that he was guilty of second-degree murder.
Well, we presume that. We don't know what was going on in that jury room. And I have not criticized the jurors. I think that there was more evidence that should have come out. And one of the things I have always said is that the video that is being shown is one-dimensional. It did not show the officer's view, and that was Jason's view, of what's going on. It's his life that he believed was being threatened. And I don't think we saw a clear view of what he was seeing. Certainly, he did not back off from the fact that he believed that Mr. Van Dyke had seen Laquan McDonald raising the knife up to his chest. And I think that that's an important issue, but the video doesn't capture that.
And yet, your union has opposed the use of body cameras. And as you just mentioned on the stand, Van Dyke repeatedly said that the dash cam video did not, as you say, reflect his point of view. Would a body camera have been a good idea in that case?
Actually, the closest that comes to the officer's view, and I have already asked the city about this, is glasses where the camera is mounted on the glasses. And I've already talked to the city about that because that gives the most accurate view. The body cam is lower, much lower on the body, and doesn't actually give you a very clear view of what the officer is looking at.
Does Jason Van Dyke bear any responsibility for Laquan McDonald's death legally?
You know, when you're talking about legally, I think you're going to have to ask a lawyer about that. I can tell you this, that the death of Laquan McDonald affects Jason deeply. I witnessed him praying on a daily basis. I think that he takes this very seriously. He is a devout Catholic, and I think that is being lost on this, that he does take this seriously. Previously,
you have said that Jason Van Dyke has the union's full support. Still true?
Still true.
Kevin Graham, thank you so much for joining us. We very much appreciate it.
Thanks for having me.
I know it was a busy day for you. And one editorial note for viewers tuning in for Washington Week. That program will air tonight at 8 o'clock, immediately following this special edition of Chicago Tonight. Laquan McDonald's family avoided reporters at the courthouse this afternoon and instead spoke at Grace Memorial Baptist Church on the city's west side. That's where Laquan's great-uncle, Reverend Marvin Hunter, preaches. Paris Schutz is there and joins us now. Paris?
That's right, Phil. We are at Grace Memorial Church on the west side in Lawndale. As you mentioned, Reverend Marvin Hunter is the pastor here. He is Laquan McDonald's great uncle. His niece, Tina Hunter, is Laquan McDonald's mother. We're told she was not in the courtroom today for the verdict. He says she is very ill, but no doubt pleased at what has transpired. Now, as you know, Laquan McDonald's had a very difficult life. He had a very difficult history with his family. He was a ward of the state for much of his life in the custody of DCFS. He also was in the custody of different family members. He suffered abuse. There were substance abuse problems in his family, so I asked Reverend Hunter about some of that family history, but I started by asking Reverend Hunter what he wants McDonald's legacy to be now, going forward, that the verdict is set in stone.
What I would like to see is systemic change in the law, which we call a contract, actually, an FOP contract. I believe that a lot of this problem that we're dealing with right now stems from the FOP contract, because in that contract, it ties the hands of the administration of the Chicago Police Department to be able to fire bad police officers. All police officers are not bad. We have some wonderful men and women that are part of the Chicago Police. I'm very proud of the Chicago Police Department. However, those bad apples are so bad until they make the whole department look bad. And so in that FOP contract, what I discovered as I look at it more and more is that it violates our 14th Amendment rights. And as it violates those rights, it also shows me that they have hidden Jim Crow laws in there. And so just as Emmett Till gave us Rosa Parks and Dr. Martin Luther King and the Montgomery boy bus cop, and then they changed Jim Crow laws in Montgomery, and then begin to change the Jim Crow laws across this country. I believe that the death of Laquan McDonald and us working with legislators in Springfield to put forth a bill to change that FOP contract so that Chicago would not be held hostage to Jim Crow laws hidden in that bill, violating the 14th Amendment rights of the people of the citizenry of Chicago, would be great change for us.
All of us throughout Chicago, we've learned a lot more about Laquan McDonald in death than most of, I guess, the broader city knew in life. But what we read about him was that he was a ward of the state for a lot of his life. He had custody with different people. Why was there such a struggle? Why did he face such a struggle in having, a solid family around him to help bring him up?
Well, the truth is, the story was distorted. Remember, they were trying to save the life of a rogue police officer. And so in order to do that, they tried to try this in the court of public opinion as opposed to what the facts are. The facts is that Laquan, in his early life, his mother was a teen mom. She was very young when she had him. She was raised by her grandmother. Laquan was actually raised by his great-grandmother, which was this elderly lady that had raised all of her children, now her children's children, now her children's children's children. And so that being said, they came up, Laquan and his mother pretty much came up as brother and sister almost, instead of mother and son. It wasn't until later years that Laquan's mother had began to grasp and attain the skills that she needed to be the example of motherhood for him. In fact, if Laquan had been allowed to live 1 month, he actually would have been back into full custody of his mother, and they were on their way to living a normal life. So it's not like he was a throwaway kid. She had been working with all of the resources that she could obtain to bring herself to be the mother for her child that she had always wanted to be. She always loved the child and still does to this day.
What is your message to Jason Van Dyke? You mentioned earlier that you never saw him ask for forgiveness. So what do you want him to know tonight?
I want Jason Van Dyke to know that healing does not take place until the realization of a problem begins to take place in his mind. Right now, his best friend is time, but the reality of it is I'm asking God to have mercy on his soul, but me just asking is not enough. He must ask. He must ask God. He must rely on that God that he says that he talks to from the Catholic Church to have mercy on him. But in order for that God, even that God, to help him, he must become real with himself, that this is what I've done is wrong. And I followed the lie, and I'm sorry.
That was Reverend Marvin Hunter, Laquan McDonald's great uncle. We're also told that Democratic gubernatorial candidate J.B. Pritzker called Reverend Hunter just a few hours ago to offer his condolences. And as you heard, Reverend Hunter is trying to get some kind of legislation passed in Springfield in the coming months in honor of Laquan McDonald. That's it for us outside of the Grace Memorial Church in Lawndale. Phil, back to you.
Thank you, Paris. And now to Brandis Friedman and some of the journalists who have followed this case closely. Brandis.
And Phil, for 3 weeks, journalists and activists inside and outside of the Van Dyke courtroom have kept a close eye on each witness, each argument and exhibit presented by the prosecution and defense. In fact, today, the media received accolades from the judge and even Jason Van Dyke's defense attorney.
We've had members from the media, both broadcast and press journalists. They've just been fantastic. Everybody's been really outstanding. The reporting on this has been very important because we need transparency, and especially a case like this.
I want to thank actually the press. You guys have been really good to us and let us do our job. So other than that, thanks, guys. Have a nice weekend.
Since the release of the video showing the fatal shooting of 17-year-old Laquan McDonald nearly 3 years ago, the city has been divided. Now, Chicago moves on to the next chapter in this story. Joining us are several journalists who themselves have been witnesses to this historic case. Independent journalist Jamie Calvin, who broke the story of the Laquan McDonald shooting after questioning the official police account. Attorney and journalist Kimberly Egoin of WVON 1690 AM, who's been in the courtroom covering the story. Political journalist Greg Hines of Crane's Chicago Business, and Chicago Sun-Times columnist John Fountain. Colleagues, thank you all for joining us. First, what was your reaction to the verdict today? Jamie, let's start with you.
Oh, I think this was a historic moment in the city, and you felt it in the courtroom. I mean, it's hard to describe just the atmosphere in the courtroom and the sense of something momentous happening. So that registered. I think there was also a very powerful moment in which the clerk, an African-American woman, read the verdict, which included a finding of guilty on second-degree murder charges. And then each of the counts, 16 counts of aggravated battery with a firearm. So each bullet a crime. And in a city that in which the word 16 shots have rung out for years, it was an incredibly powerful moment to hear that. Shot number 4 guilty, shot number 5 guilty.
Kimberly, what was your reaction?
So initially, when the jury sent a note earlier and they were asking how to approach the 16 counts of aggravated battery with a weapon, I knew that they probably were going to convict him. I thought it was kind of fast for them to get to the conclusion on first or second degree murder, and I thought of the conviction, but my focus shifted to something when the verdict actually came in. We have spent so much time in this city talking about what the reaction will be if there is a not guilty verdict. How will the African American community react, and what will they burn up, what will they destroy? That we never focused on what happens with a guilty verdict and the people who will be against that. There are many people, many who are police officers, who are not satisfied with the verdict that was turned in today. And we haven't discussed the idea, will there be a stoppage? Will they go fetal? As the mayor mentioned several years ago, that they went fetal because we were just protesting in the streets. So I started worrying a little bit about that, and there are a lot of people who are actually worrying about that.
Greg, even defense attorney Daniel Herbert said that he was not surprised by this verdict. What was your reaction?
Relief would be the first word. This case has been a tragedy from day one. It's been a tragedy for Chicago, for Van Dyke's family, and Van Dyke, for Laquan McDonald and his family. This is about as well as this could have turned out. I thought this case was over the day the tape came out. I don't know how any rational person could have looked at that tape and said, no problem, let him walk. If the jury had let him go without any kind of a conviction, the damage to this city would have been inestimable. Now we move on. We have a verdict. In my opinion, it was a correct verdict, but now we look for the balance, because this city needs two things. We need our police, and we need them to work, because there are bad guys out there. All these murders and robberies and whatever we hear about all the time, they're not made up, they're real. We need the boys and girls in blue to defend us, but at the same time, they have to get along with the community they're serving. You can't have a big part of Chicago being not trusting, and more than not trusting, almost hating the police who are supposed to be their servants. We need to find that right balance to get both.
John, I'm seeing some head nodding.
Well, I will tell you that it was profound for me, although I have mixed feelings. I was sitting in a coffee shop writing my column for the weekend, and I was watching the verdict stream live. And quite honestly, when they said second-degree murder, a conviction, I closed my laptop and tears started running down my face. And I feel a sense of relief as a native son who grew up on the west side of Chicago, in North Lawndale, in K-Town on 16th Street. And I'm not sure what this verdict means for young men who live on the west and south sides of Chicago. At the same time, I'm happy because I understand the history of what has happened to black men in America, from slavery to Jim Crow, that this is the home of Fred Hampton and Mark Clark, who were murdered in their beds. This is the place where Dr. King was stoned. This is the place, the home of John Burge, and the allegations that black males were tortured and electrodes attached to their genitals and false confessions. And so I celebrate in some sense, and I think celebration is a little too strong a word. I'm contented, but I stand at a place of love and hate for this city that I love, but so much of it I hate.
Jamie, you cracked this case, or cracked this story several years ago. Did you expect this outcome?
Never, never. I could never have imagined when I first heard the name Laquan McDonald, which was probably 10 days after his death, that anything like this would unfold. And, you know, I think to go to what Greg said, I think there's a danger that we overread this verdict. I mean, it's really important. It's really, but this was a very narrow part of the larger struggle we're in the city to create equality under the law and public safety both. And so we don't want to overread it, but the alternative of an acquittal or a hung jury for the city going forward would have been an incredible setback. So this is a kind of necessary condition to now get to work on addressing the underlying institutional systemic conditions that allow for this kind of abuse of state power, and then hide it from the public. And you know, this was a narrow case. We've been talking about the institutional issues for years, and that arose out of the Laquan McDonald case. But this was a murder case. The question in the court was, did Officer Jason Van Dyke murder Laquan McDonald? Now we have an answer to that question, and it has these larger public meanings. But we don't want to mistake it for now we have addressed the fundamental problems. We haven't.
Let's be hopeful, if I might. I mean, it's going to be real easy for particularly going into a mayoral election when politicians are going to do what politicians do, which is exaggerate and lie and try to use things at their advantage to get elected, to go overboard. But amid the dispute, there are some grounds to try to bring everybody together on a rational basis. Your guest before, a little while ago, the gentleman from FOP, named one thing that's absolutely critical. There's got to be more training. There's got to be better training for line officers so they know what to do, so that somebody can't get up and say, well, I was trying to just shoot like crazy. That's what they told me to do in school. There's a way to work this out if people of goodwill want to do it.
And we have a process for that going forward. We have the consent decree. We have, you know, a formal process now, a kind of blueprint for police reform. But it was critically important to hold this officer accountable for us to be able to look at the systems that failed him as well as Laquan McDonald.
So Van Dyke's attorney says that he is considering an appeal. Kevin Graham also earlier said that there will definitely be an appeal. I think Daniel Herbert said that they're thinking about it. He claims his client was a, quote, sacrificial lamb amidst all of the ensuing media scrutiny from folks like us. Do you believe that Van Dyke got a fair trial?
Yes, from what I can tell. And I'm not a lawyer, but my understanding of the law is if you're going to appeal, you can't appeal on the facts. You have to appeal on the basis there was a miscarriage of justice, something didn't work procedurally. Maybe this change of venue thing, although everybody's going to hold their own opinion just looking at the jurors. So I saw talking, these don't look like biased people. These look like people who did their job and get in and weigh the evidence that they were supposed to. So you never know, but I would doubt it.
Kimberly, you're also an attorney.
Even in the judge didn't rush to judgment as far as when they said, you know, we can't seat a jury. He said, well, let's give it a shot. Let's give it a shot. He gave them so much leeway, so much leeway. So I think that it was as fair as I've ever seen a trial.
John, do you think this verdict will deepen the division between communities and the police? Where do you think we're going next?
I don't know. I think it is a potential starting point to discuss the larger systemic issues. You know, it is, if I can just hearken back to that phrase, sacrificial lamb, the only person whose blood was spilled on the streets of Chicago, in this case, was Laquan McDonald's. It ran red on the streets of Chicago. Jason Van Dyke got to stand before a judge and a jury of his peers. He got to say what happened that night from his vantage point. The only voice we didn't hear in this case was Laquan, because he's dead. And so Laquan didn't get a fair trial because Jason Van Dyke became judge, jury, and executioner on the night that he shot him 16 times.
We're almost out of time.
Well, I just
final word
quickly, yes. The idea that police officers are infallible, if the FOP cannot back off of that position, that no one who ever is a police officer ever does anything wrong, I don't know how we get to the middle ground that everyone is talking about here.
Okay. lots to think about. You guys, you all have left me speechless. We've got Jamie Calvin, Kimberly Egowin, Greg Hines, and John Fountain. I want to thank all of you for joining us on Chicago Tonight. And back with Phil right after this.
And that's our show for this special edition of Chicago Tonight. Don't forget to stay connected with us by signing up for our daily briefing. And please join us next week live at 7. Now, for all of us here at Chicago Tonight, I'm Phil Ponce, and I thank you for watching. Good night.
Closed captioning for this program is brought to you by Robert A. Clifford and Clifford Law Offices, sponsors of the Chicago Police Memorial Foundation, dedicated to providing support for the families of officers injured or killed in the line of duty.